Hello, everyone. We'll begin in about 1 minute with this webinar. Welcome, everyone. My name is Michelle Lavoie. I'm the director of PICUM, which is the Platform for International Cooperation on Undocumented Migrants. Thank you for joining us today for this webinar. Thank you very much to our speakers for accepting our invitation and for sharing your expertise. Before we begin, I'd like to just say some housekeeping rules. We will hold the webinar in English and French and Spanish. There will also be interpretations. So you just have to click on the little globe icon on the bottom of the Zoom window to choose the language that you'd like to speak in. If you have any technical issues, please contact Irene or Chloe through the chat. The website is being recorded. It'll be available on PICUM's website shortly, and it's being live streamed on LinkedIn. And you can pose any questions that you might have to the speakers in the chat at the bottom of the screen. So today's webinar is on seamless procedures, ensuring rights and protection beyond asylum in the EU. To begin, I'd like to start with why we've chosen this title and what seamless procedures are. In recent years, a number of EU legislative proposals, first and foremost being the EU Pact on Migration and Asylum, have explicitly pursued the objective of creating seamless asylum and return procedures by, quoting the European Commission, quote, closing loopholes between asylum and return. When setting this goal, policymakers assumed that people entering or living with irregular migration status in the EU can be easily divided in two perfectly separate groups, those who should receive asylum and those who should be deported. However, this framing doesn't really correctly represent the reality of people who are living with irregular migration status in the EU. The oversimplification is not only wrong, but it's also harmful. According to official estimates, every year 300,000 people cannot return from the EU for reasons including non-refoulement, because they were trafficked, for family reasons, for health reasons, for best interests of the child, or for other reasons. So today, during the webinar, we're going to discuss the people who don't fit into this seamless procedures or into this asylum/return binary approach, and how we can ensure that those who don't fit into this approach can have access to rights and protection. And this webinar is also going to be an occasion to present the outcomes and the recommendations from PICUM's new report called Barriers to Return, Protection in International, EU and National Frameworks, which analyzes different policies adopted by EU member states to provide rights and protection for people with barriers to return. So once again, we'd like to very much thank our panel of speakers, and I'd like to introduce them to you right now. The first person we will be hearing from is Marta Gionco, an advocacy officer at PICUM, who will present some of the conclusions from the report. Then we will hear from Alberto Pasquero from ASGI, which is the Association for Juridical Studies on Immigration in Italy. ASGI is an association of lawyers and academics focusing on migration law. Then Wiebke Judith from ProAsyl, an organization which advocates for the rights and defends the rights of refugees and migrants in Germany. And the member of European Parliament, Birgit Sippel, S&D from Germany, the rapporteur on the screening regulation. So thank you once again to all of you for joining. I'd like to first invite Marta to present PICUM's new report, which is called Barriers to Return, Protection in International, EU and National Frameworks. Marta, can you please highlight for us what are the main findings of this report?
Thank you very much, Michelle, for this question. The report Barriers to Return, and I think Hilmi has just put a link for everyone in the chat to be able to read it later. The report looks at different reasons for which a binary approach to migration, which only looks at asylum or return as only options for people who are undocumented or arrive undocumented in the EU, is incorrect and can be harmful. And the report also compares different policies which are aimed at ensuring rights and protections for people with barriers to return, including providing some recommendation. As Michelle just mentioned, in recent years, several EU migration policies have consistently focused on increasing the rates of returns, we can say maybe at all costs. But this approach rests on the idea that return or deportation are the only options for undocumented people. However, this idea does not reflect the reality in the EU and can actually have very harmful consequences. In the report, we look at two main reasons for which an approach which only looks at asylum or returns can be harmful for undocumented migrants. First of all, there are many legal and practical reasons for which people who don't qualify for asylum actually should not be deported or returned. The legal reasons include, for instance, the principle of non-refoulement, but also protection of family and private life, the best interests of children every time the children are involved, therefore also for families, and protection on the grounds of statelessness, just to name a few. And it's important to underline that the assessment of these reasons actually falls outside the scope of the asylum procedures. In the report, we also look at different court decisions from the European Court of Human Rights and European Court of Justice. And these decisions confirm that states were violating the law when they decide to return people without having adequately assessed whether they would be at risk of torture, what would be the impact of return on their health, including mental health, and also what would be the impact on return on the family and private life, including in situations in which people don't have family because private life itself can justify the right to stay in the EU. In addition to these legal reasons, there can also be practical reasons for which return and deportation may just be not feasible. And these include, for instance, because sometimes people don't have passports to travel with. And the practice of some countries to deport people based on laissez-passer is also very problematic because it can return people to countries in which they may be left undocumented as well in their own countries of origin. And in some cases, people may also not be able to return because they might have health circumstances for which they might be unfit to travel. They may not be able to take a flight. It's really important that these fundamental and practical reasons are comprehensively assessed before a return decision is issued, and in any case, before someone is deported. In addition to these legal and practical reasons, there is a second reason for which it's wrong to assume that everyone who does not qualify for asylum should be deported. And this is because in the majority of EU member states, there are already other permits which are accessible to people who are undocumented. And these include, but are not only limited, people with barriers to return. These include, for instance, humanitarian permits, but also permits for medical reasons, permits for families, permits for children, and permits for victims of trafficking in human beings. A study by the European Migration Network in 2020 found that there are at least 6 different statuses which are available for people who cannot return or who need protection besides asylum. And in at least half of these cases, these statuses are not examined by the asylum authorities and are not part of the asylum procedure, which is why it's really important that these procedures remain accessible independently as well. The very same EU legal framework also requires member states to analyze whether people might have access to permits and also to issue permits in specific cases, including victims of domestic violence who have a dependent status. And I'm referring here to the Citizens Directive and the Family Reunification Directive. The EU legal framework also requires states or encourages states to grant permits, for instance, for victims of human trafficking. And this is the Residence Permit Directive, and victims of labor exploitation with regard to the Employer Sanction Directives. The reason why we are discussing this today is because there are several legal proposals which are presented at EU level and being discussed now by the European Parliament and the Council, which would have the impact of reducing access to these different permits. And in practice, this would be the consequence if these proposals oblige member states to issue a return order immediately after an asylum procedure is rejected. This is, for instance, the case of the Recast Return Directive and the Asylum Procedures Regulation, but also several other proposals, including in the Pact, which would consider asylum or return as the only procedures which would be accessible for undocumented people. It's important that ensuring access to different pathways remains possible in the EU legal framework, because this is the only way to avoid situations in which otherwise people might be stuck in limbos. They may be not be in the position to return, but also they will be excluded from accessing permits in the countries in which they're living. Or even worse, they may be at risk of being deported to countries where the fundamental rights violations will be at risk. Now, after having explained why an approach which solely relies on asylum and return is incomplete and can be harmful, I would like to quickly turn to what can be done in practice to ensure protection for people with barriers to return. In our report, we have looked at 10 different case studies from 8 different countries. We have looked at Cyprus, France, Germany, Greece, Italy, Netherlands, Spain, and Poland. And Alberto and Wiebke afterwards will present 2 of these case studies more in depth. But our comparisons of the different practices have shown that there are actually many differences on how member states regulate access to permits for people with barriers to returns. And these differ, for instance, in terms of accessibility, but also in terms of who is covered by these permits and what do these permits entail in terms of rights and protection. Based on this comparison and based on several meetings with our members in which we have discussed what is the impact in practice of these permits at national level, and we have identified 4 key recommendations which need to be fulfilled in order to ensure that people with barriers to returns can have access to protection in the country in which they are living. The first recommendation is when we look at the initiation of the procedure, it is important to ensure that the authorities examine automatically whether someone qualifies for a permit on an individual basis. And this should be a mandatory step, which should be done before a return decision is issued. In addition, it's also important that people are able to apply to these permits independently, because in some cases, the authorities may just not be aware of the circumstances that may trigger some of these permits. And this is, for instance, the case in Italy, as Alberto will present later, in which the permit for special protection reasons can be accessed by individuals on their own initiative, but also is examined by the asylum protection authorities. Secondly, it's also essential that permits for people with barriers to return grant access to the labor market and to social services. A good practice in this case is what we have identified with regard to the permit for medical barriers in the Netherlands, in which access to healthcare and to rights is also granted while the procedure is still ongoing. Thirdly, it should be possible to convert these permits in long-term permits, because very often barriers to return endure through time. And for this reason, it's quite important that people can also have a long-term perspective, which also allows them to have more certainty over their future. And fourthly, it's essential that these permits do grant protection from deportation and detention. To summarize the 4 elements, we looked at accessibility, access to labor markets and social services, possibility to apply to more secure statuses, and protection from detention and deportation. I will now close here and would be happy also to reply to any questions afterwards. Thank you.
Thank you very much, Marta, for this brief but somewhat thorough overview of the report, which looked at many different legal, practical reasons, and then also these recommendations and case studies, which we'll hear more about now with 2 of them. I think you mentioned also the 2020 European Migration Network study, and I think you referred there to, was it 60 protection statuses? So maybe also useful to share some of these links, and also to note in the chat that we've shared the link in several languages of the report that Marta has just proposed for review, that PICOM has just released. So now we'll go to the other panelists. Thank you very much. I'd like to now ask Alberto Pasquero from ASGI. As Marta has said, this is one of the case studies that we're looking at Italy's legislation. So after a number of legal changes in 2020, Italy introduced a special protection permit, which provides for the possibility to obtain a permit for people with barriers to return. Alberto, could you tell us who are the beneficiaries of this permit and how can they access it in practice?
Yeah, thank you very much. I need to be try and be at least as good as Marta in terms of combining time and notions that I want to share with you. But indeed, this is a permit, so-called permesso per protezione speciale, special protection. This was introduced at the end of 2020 after almost 2 years of suspension, or actually elimination of the permit for humanitarian protection that was, as you know, it was removed from our law by by government, by the then government, and left a lot of people undocumented. These were people who could have received a permit on humanitarian grounds from the Commission for Asylum upon asylum application, or people that had already received this kind of permit of stay in the past, and since it no longer existed, they could no longer extend it, and so they became undocumented, they became irregular, and so really it did not serve the interests of anybody, frankly speaking, including employers and the people themselves, of course. And so there was a sort of consensus in the new government that came after that some form of complementary protection had to be introduced. So the people who can apply for this permit is, well, frankly, it's two categories of people. Either those who are in any way prevented from being returned based on Article 2 and 3 of the ECHR, and this includes also notably persecution in their home country, or torture, or inhuman and degrading treatment. And these are categories that would receive asylum, probably, if they applied for it. There are some slight differences, but let's not get too technical. But they could either apply for asylum, or maybe they could apply for asylum but have exclusion clauses, so they commit crimes, or otherwise they're socially dangerous. So they could not get asylum, but they can also not be repatriated. And this category of foreigners is going to receive today the new permit for special protection. So this is a first category, and it's really upon the person themselves to either apply for asylum or apply directly for this permit of special protection, even though if somebody has prerequisites for being recognized as a refugee or a beneficiary of subsidiary protection, still the asylum channel would grant them more rights, is a safer option. But the real added value of this permit for special protection is for foreigners whose rights under Article 8 of the ECHR would be violated in case of repatriation. And this is categories of foreigners who typically have resided in Italy for a long time, who have family ties with Italy, or private ties with Italy anyway. And this is the law that provides for some criteria according to which special protection can be recognized, even absent grounds under Article 2 or 3 of the ECHR. Here we're really talking about de facto possible channel of de facto regularization. So even if you're completely undocumented, either because you never had papers or you used to have them but lost them, then you can always activate two channels in order to obtain this protection. Either, again, apply for asylum, so a subsequent application, or maybe even a first application if you have never applied for asylum. And the Commission for Asylum can grant this form of protection after examining the prerequisites for international protection. So either you can obtain it as a fallback option in case you apply for asylum and you don't meet the requirements, or you can completely avoid the asylum application, the asylum channel, so to speak, altogether, and apply directly to the police. The Questura, the local police authority, will decide on your application, so will assess whether you've been in Italy quote unquote long enough, if you have quote unquote a sufficient integration in Italy in terms of labor, in terms of language, of family ties and private ties. And the Questura, it's a bit peculiar. In Italy, we like to make things complicated all the time, at least our legislators do. So even in this case, even when you apply directly to the police for this permit, the police will ask the opinion of the Commission for Asylum. as if police was completely unable to assess human rights grounds in Italy. They have to rely on somebody else who will make a human rights assessment for them. And this opinion of the commission is sort of binding on the police. So if the commission says yes, then the police has to issue this permit. So the authority that decides, no matter which channel you pick, either the asylum channel or the direct application channel, at the end of the day, the commission for asylum is going to, the local commission for asylum is going to decide whether from a substantive standpoint you have the satisfy all the conditions or not. This, just to conclude, in terms of content, this is a 2-year permit that gives the beneficiary, the holder, all the rights that they need. They can work, they can access social services, healthcare, social benefits, and so on. And it can be extended in any case. Whether it can be converted into a different permit, it's a matter of interpretation. It appears that if you apply directly to the police, then the permit you get cannot be changed into a work permit. If you apply for asylum, then it can, but it's a bit complicated, and I suspect there's going to be some litigation on this point, because it seems the system as it is now is a bit irrational. So hopefully we'll meet again in a few months, if you like, and I can update you on the state of play. For the time being, I would stop there, and I'm happy to answer any questions later.
Thank you very much, Alberto. Very interesting to hear about some of the procedures linked to this, about the different ways of applying for it, also what the individuals receive when they actually are granted it, the length, 2 years. So I'm sure that we'll have some reflections from those in the audience, maybe some specific questions. Once again, if you have any questions to Alberto or to any of the panelists, please feel free to put them in the chat, or also type them. If you're watching this live stream, you can type them in the chat on the live stream as well. So now we'd like to go to Vivka Judith from ProAsyl. And I'd like to ask you about the situation in Germany, where individuals who cannot return or be deported receive a temporary suspension of deportation, known as the Duldung. What are the practical consequences of receiving a Duldung?
Yes, thank you so much also for the invitation. Perhaps just before I start, just a quick word. So our system of Duldung is actually pending reform, because the coalition agreement from last year actually stipulates a number of changes. But as so far, like, none of those legislative reforms are kind of started. I'm just going to present what the law says right now, and perhaps later we can have a quick look at what might come in the next months in Germany. So perhaps just as a quick start, so in Germany during the asylum procedure, the Department for Migration and Refugee checks if refugee protection, subsidiary protection, or the German national ban on deportation applies. So the latter is a bit more similar to what was just described for Italy, but it's really kind of an Article 3 ECHR kind of check. So it doesn't encompass that much more. And it's still like the threshold is still pretty high to get that. And so if none of this is the case, the person is rejected by the Department for Migration and Refugees and has to leave the country, gets like a notice that they should leave the country. For the time that they are still in Germany, they are considered to be tolerated, which is what we call the Duldung. There can also be different paths to kind of ending up in Duldung, but I would say that this is kind of more broadly like the most common track how people end up with this status or non-status in Germany. So as such, having a Duldung is basically what every registered person in Germany should have at the very least. And this is confirmed by our highest courts. However, in practice, sometimes we do see local administration not giving out Duldung, but this is like something that shouldn't happen. Like, just from the logic, every person who's registered in Germany should at the very least have a Duldung. The reason for this can range from having family ties in Germany to sickness to barriers to return, such as lacking identity documents. And so it's really quite a variety of why the authorities will give you a Duldung. But however, the Duldung does not protect you from being forcibly returned. You are still obliged technically to leave the country, and it only grants access to limited social benefits and healthcare. A person with Duldung may be allowed to work, but it's not as such a guaranteed right. And perhaps also to make things even perhaps a bit more confusing, the duration for a Duldung can really depend on like the singular case. It can be handed out for just 3 months, it can be 6 months, it can be longer periods. Like it really depends a bit on the individual case and how the local administration handles it, because this is up for the local foreigners offices. So we have quite a variety of practice when it comes to this. In the last years, we have really seen a bit of a diversification of this non-status, and that we now have special Duldung for people who work and for people who do an apprenticeship. These types of Duldung give a bit more protection, but there are still no actual permits. And I think that's something kind of important to understand, that a Duldung is not any type of permit to stay in Germany. So it's really kind of a legal limbo kind of situation. It only grants you like certain rights and you are documented from the perspective of the German state. Likewise, we also now have a worse status, which is, or we call it Duldung Light, which includes an automatic ban to work, and it acts as a barrier to any prospect of regularization. This was introduced specifically as a punishment for people who are considered to withhold information on their identity. And the idea is that because we do have certain provisions which make it possible to regularize your stay, but you have to be already tolerated for a number of time in Germany. And if you have the Duldung Light, this doesn't count for the regularization process. And this is one of the things that is supposed to change. So the Duldung Light is supposed to be struck out. However, this kind of barrier to regularization is still supposed to be kept. So we will see how this will play out. Perhaps also to get a bit of an idea of who this actually concerns in practice, there are like roughly 242,000 people with Duldung in Germany. So this is quite a substantial amount of people. And when we look to the main countries of origin, we have as number one, Iraq with 30,000 people, Afghanistan with 26,000 people, and then Nigeria with 15,000 people, and then Russia with 13,500 people. So especially looking at Iraq and Afghanistan, it's clearly countries which have seen a lot of conflict and war, etc. So it's quite surprising, I would say, that, you know, these are kind of the countries where the largest amount of people have this kind of non-status in Germany and actually did not receive protection, or the protection was taken away. You know, it's different cases, but it really kind of shows how a lot of people from very problematic countries end up in this Duldung in Germany. Also, interestingly, when you look at the numbers, roughly or like a bit less than half of these people have been staying with Duldung for around 5 years in Germany. So this really shows how what on paper is perhaps meant to be just kind of a in-between state, like not really status, but like non-status till you're returned or you return yourself. It actually is, for a lot of people, somewhat of a long-term situation in Germany with, as I said, very limited rights and like really legal uncertainty. Also, these like a bit over 100,000 people, though, could have a new possibility when the things that were seen in the coalition agreement would actually come out to play. Perhaps that's something to look at later. But yeah, so perhaps just as a quick overview of what Duldung actually means or what it doesn't mean and who's concerned by this in Germany. Thank you.
Thank you very much, Wiebke. Very interesting to hear all of those details, some of the numbers, especially at the end, the 242,000 people with Duldung in Germany, the reasons why people can actually be granted it, the fact that some people can live with it for 5 years or more, I can imagine. So, I mean, some of this, very good overview, and let's see if we can also maybe go into it a little bit more in a second round. mentioned. But let's go now to our member of European Parliament, Birgit Sippel. Thank you very much for joining us, Ms. Sippel. We'd like to ask you about some of these instruments that are currently being discussed now in migration and asylum. And we had mentioned kind of at the beginning of the webinar that there are several proposals that the European Commission has been publishing in recent years, which would impose an obligation for EU member states to adopt a return decision together with the rejection of an asylum application. So this, as we've heard Marta also present on earlier in the panel, this would risk closing the space for national level permits to become applicable. These proposals are currently being discussed by the European Parliament and the Council. From your perspective as a member of the European Parliament, how can EU policies ensure that the rights of people with barriers to return are protected? And what can the European Parliament do to protect their rights?
Thank you, and thanks a lot for inviting me, taking part in this really important debate. And it's true, we are right now entering the very crucial point of debates in our internal negotiation on the so-called new pact. And I fully agree with Marta and others that it's of utmost importance that we ensure, while debating all these files, that national residence permits continue to be applicable, especially given the really high complexity of the system proposed by the Commission. Now, first of all, I will start by saying that although I welcome the Commission's ambition to provide a new momentum in a long deadlock debate in the Council, I do not see many really new elements in this so-called new pact. Rather, I see the attempt to square the circle by trying to accommodate conflicting concerns from all the member states, yet in particular of those who would even go as far as breaking EU law in their rejection of asylum system based on solidarity as clearly stated in our treaties. And unfortunately, we do not see this step towards the member states' preferences paying off for the Commission, as the debates are as stark as they have been in the last 6 years. So we don't see much movement in the Council. Nonetheless, we in the Parliament, we are working on the proposals and are currently trying to find compromises among the political groups for a joint negotiating mandate, because all the different files are linked to each other and we're trying to get a harmonized solutions, at least from the Parliament side. I cannot give the concrete timelines, especially not for the other files where I'm not directly involved, but for the screening regulation for which I'm the rapporteur, I'm hopeful that the common position is not too far away. Let's see. Now for today's topic, I believe that the screening proposal plays a crucial role, as it is supposed to be the first procedure for irregularly arriving persons in the EU and should play a key role in referring them into the appropriate procedures. However, the Commission proposal may exclude some of the national permits that exist, as, and this already was indicated by other speakers, it only foresees 3 outcomes: asylum procedures, return procedures, or refusal of entry. There are several human rights grounds which should prohibit the return of people who are not granted or even seeking asylum, such as the protection of family and private life, health reasons, and the best interest of the child. As the PICOM report already notes, at least half of the 60 national protection statuses existing in the EU are currently examined by other authorities than those handling asylum applications, and in many instances are not part of the international protection procedure. Therefore, I believe it's important to ensure that the screening does not close the avenues to those national protection or residence statuses, which is why I have included amendments to this effect in my draft report. My underlying principle when drafting the screening report was to make use as much as possible of already existing EU law and not introduce new rules into it as far as possible. And this should underline the fact that we already have many safeguards, procedures, checks, and obligations. However, in many cases, we see an issue with implementation, and unfortunately, the Commission is not scrutinizing this closely enough. To ensure that the avenues for alternative statuses are not closed, I have mainly relied on including clear references to Article 6, paragraph 5 of the current Schengen Border Code, which gives member states the opportunity to allow persons to enter their territory even if they do not fulfill the entry criteria, in particular for humanitarian reasons. When drafting the report, I could not have that Article 6.5 of the Schengen Border Code would already play such a big role as it does now in the context of persons arriving from Ukraine, as the Commission is explicitly referring to it in its operational guidelines. The added benefit of this provision in the Schengen Border Code is obvious now, and we must ensure that it continues to apply also in the screening. People also highlighted the lack of access to legal aid during the screening and the lack of an appointment of a guardian during the procedure. I tried to address both issues in my draft report by including provisions that provide effective access for organizations and persons providing advice and counseling, including legal assistance and representation for everybody, but in particular to persons held in detention facilities or present at the border crossing points, including transit zones at external borders. Furthermore, I have introduced a new article that introduces the provision of a representative to unaccompanied minors, similar to the provisions agreed upon in the provisional text of the recast of the Reception Conditions Directive. Another issue I would like to highlight in need of discussion is the refusal of entry, which is a foreseen outcome in the screening, and which may also have effects on the application of national statuses. We will need to discuss this in the Parliament in more details in the next weeks. What I have included in my screening draft is the possibility of legal remedies against the referrer. This I have not included in the draft. The reasoning behind is that one of the key objectives I had in my draft was to keep the screening as short as possible. So a maximum of 5 days, that's my proposal, without the possibility of an extension. Including a legal remedy in the screening itself could undermine this objective by preventing the completion of the screening until the judicial review is completed. However, in close cooperation with our S&D shadow on the Asylum Procedures Regulation, we have included amendments for judicial remedies against the outcome of the screening in the asylum procedure. Nevertheless, this is a topic we will continue to discuss internally in detail. Overall, I agree that appeals should or must have suspensive effects to avoid deportations before a decision on the appeal is taken. So I hope this gives a short overview about the debates linked to the screening regulation, and I'm happy to follow the debates and answer additional questions. Thank you.
Thank you very much, Ms. Zippel. Very good to hear about all of the things that you've included in your report, kind of a little bit on the state of play as well, and all of those particular items. I think, and so very much welcome anyone to raise any questions in the chat or on the live streaming. And in the meantime, I wanted to ask you a follow-up question. As rapporteur of the screening regulation, you also work on the proposed mechanism for fundamental rights monitoring at the external borders. Do you think that this mechanism could also play a role to contribute to prevent people from not being deported in violations of their fundamental rights?
That's an interesting question. And to be honest, it was not foreseen in the proposal of the Commission. So it's possible, but we have to significantly extend the scope of the mechanism compared to the Commission proposal, because the Commission proposal, it only focuses on the screening procedure itself, and this really is much too narrow. So I included amendments, and I'm happy to see that other political groups have also proposed similar changes to extend the monitoring mechanism not only to the screening procedure itself, but also to border surveillance, asylum and return procedures. And I believe it's crucial that the monitoring covers the entire procedure from irregular crossings to deportations, as we see fundamental rights violations at all stages of the procedures. And only if we have a comprehensive mechanism on all the different steps, these violations can be observed and subsequently addressed. And I hope we will get a majority on this extension of the monitoring mechanism.
Thank you. We also have another question from the European Network on Statelessness, which thanks you for your useful amendments on statelessness in the screening regulation. And they would like to know what your views are on progress towards mainstreaming better statelessness language and understanding through the pact negotiations and debates on other regularization routes.
It's not so easy to understand, because we now are in the point where we try to find the final position of the Parliament. But the question of statelessness clearly is an important point in the text of the screening, and I'm happy that different groups support this. I'm not that sure to what extent it will be part in the other files that are under debate, but what we are trying within the so-called Asylum Contact Group is to ensure that we have a harmonized line between all the different files to ensure that some principles that are in the one file do continue in all the other files. So we are still working on this.
That's very hopeful to know. Thank you for that precision. Let me maybe turn now to the other panelists with some follow-up questions. Since we have a little bit more time left, I'd like to ask Wiebke. You had mentioned, Wiebke, when you were presenting that you were talking about the current state of play with the Duldon. And you had also mentioned that there are some proposed challenges with the new coalition government agreement, in particular with regard to access to the labor market and to regularization. Can you maybe share a little bit, if you have any more information on what the state of play is with some of these proposed changes, excuse me?
Yes, of course, I'd be happy to. So a bit of a switch from Brussels to Berlin now. Yes, indeed. So last year, as probably most are aware, since last year, we have a new government, and the coalition agreement has been, I would say, particularly progressive when it comes to some of the migration and asylum policy questions, especially concerning our national law. And one of the things that has been foreseen and that really could make quite a difference, but unfortunately it's not put in practice yet, is the proposal to introduce some kind of, it's difficult to translate it quite into English, like a residence permit on trial, let's say, for like 1 year. And the idea is that kind of everyone who has been for 5 years in Germany, who doesn't have a criminal record, and who kind of pledges like allegiance somewhat to like our democracy, will get a 1-year residence permit, which should allow them then to kind of fulfill the criteria for the other regularization methods or like prospects. So it's really a bit the idea to do a bit of a cut, because as I mentioned, the problem is that while Dodung in theory is perhaps kind of more a short-term situation, it's really like for many, it's really like one Duldung after the other over many years, and there's never this like actual sense of security really arriving in Germany and knowing that you can stay. But yeah, the problem is a bit that we actually do see people getting forcibly returned right now who would be allowed to stay once this is put in the law. So we're really trying to pressure that this is finally really put into practice. There are some federal states who kind of advise their local authorities to not return those people who are here already for 5 years, but it's really only going to be for certain once this is really adopted on the national level. What we hear is that it is one of the first things that they do want to implement from their coalition agreement, because it's also like a rather easy rule, let's say. But of course, also a bit the developments with Ukraine, etc., it does put some of these things, I think, a bit behind on the agenda. But we do hope that we might have something really in the law after summer on this. And then there are multiple of other quite good rules that should change, such as that for everyone who's already in Germany, there should be no prohibition to work anymore. That also the rules on regularization should be made a bit easier, that like the thresholds should be lowered. And then one of the biggest challenges often for people in practice is how to prove their identity. So this is kind of, it has become a bit of a fixation in German politics, I would say, in the last years, that people need to prove their identity. It's of course also understandable to a certain degree from a state perspective. But what we see is often that people are being told over and over, like, you have to get a passport, you have to get a passport. And even if they have tried everything they can at this point, it's kind of never taken for granted that they can just not get a passport from their whole country. And the new government does want to introduce kind of a way to say that you kind of legally pledge that this is your identity and that this is enough, that you are considered to have proven your identity, which is really one of the main issues also for regularization, for being allowed to work, like all of these questions. It's one of these really key aspects. And then actually the Duldung to do an apprenticeship, which is a really important practical thing, like quite a lot of people try to go this route. This is really meant to be turned into a residence permit. And this would be also really great, because this actually finally gets people out of the Duldung, out of this like non-status into an actual status. So instead of trying to improve Duldung, it is important to now kind of starting to make the switch that people who are here, who work, who learn, that they actually have a permit instead of just Duldung.
Thank you very much. Those are really important potential developments, which we hope will be realized, and also within a relatively short time frame. Some of them, as you had mentioned, hopefully in the summer, maybe some of those elements will come into play. Within PICUM, we're also very much interested in the coalition agreement reference to paragraph 87 of the Asylum Seekers Benefit Act, I think, on healthcare entitlements and this reporting duty that currently exists, where people fear for actually getting healthcare, which is also one of the developments that we're also looking into. But thank you for highlighting all of those, and we hope that these will be positive as it goes forward. We have a little bit of time left. I still wanted to ask Alberto from ASGI a follow-up question. So Alberto, you had mentioned when you were presenting that in Italy in 2018, the Salvini decree terminated the humanitarian permits, which were then partially reintroduced in 2020 through the permits for special protection. Could you tell us a little bit what happened in practice when these permits became suddenly unavailable in 2018?
Well, yes, what happened is that a lot of people lost an opportunity to have a documented status in Italy. So if your permit was expiring long enough a time after, it was the legal permit. I mean, before the law was changed, if you had, say, another year of validity on your permits, you probably found a way to change it into a labor permit or another kind of permit, maybe for family reasons or so. But if you had no job in that moment, or if your family ties were not sufficient, well, then you might have lost your legal status. And this is really what happened. To partially make up for that, the following governments made a regularization scheme about which we've talked a number of times, also on PICOM's events. And this allowed for some people, including some people who had lost their humanitarian permit, to get a work permit again. But it was not until this new, so to speak, new. It's been in existence for a year and a half now. This, let's call it, new permit for special protection came into force. That people who had been living in Italy for a long time and maybe were completely undocumented at the time could have the hope to regularize their status. And we're still in the early days, despite this having been introduced a year and a half ago, but it was a year and a half full of COVID breaks and uncertainties in the application. The bylaws were not there, and then the ministry started issuing bylaws after bylaws and interpretative documents and so on. And even the police, because a lot of people, they resorted immediately to the police channel, the direct application channel, so without going through the asylum procedure once again. And a lot of local police offices, they just stayed the applications. They put them in some drawer. And in Torino, for example, which is the city I work, they haven't sent a single application that they received to the commission for their opinion. So what we see is that practice and law often differ, and so the law is there, it exists. We haven't seen such a widespread application and recognition versus denial rates that we can draw any conclusion. We don't have any conclusive evidence as to whether or not it managed to fill in the gap left by the abrogation of the humanitarian protection, which was much better in many respects. It was an atypical kind of permit, which was could be adapted to a lot of different personal situations. And it was a unique permit, one permit for everybody, both those who had humanitarian grounds, health grounds, family reasons, etc., and those who had applied for asylum and received a denial because of exclusion causes. So all of these categories would get a humanitarian permit, which was valid for 2 years. It could be converted into work. And now we see, duplication of channels, duplications of also of content, because if you received a protezione speciale, this is a special permit, because you are a refugee, but you have an exclusion clause, then your permit cannot be transformed into work. And this is some sort of duldung that was introduced in Italy by Salvini, which said, okay, if you apply for asylum, but you have an exclusion clause, you will not be expelled, but your permit can be extended, but it can never be converted into a better, more stable permit. So you will be renewed every year. Yes, you can work because we don't want you to be, to be paid, your expenses to be paid for by taxpayers. So yes, you can work, but no, you can never change this permit into a more permanent one. And this approach still exists. So we have one protezione speciale, special protection, but we have actually the content of this permit yes, it's 2 years, but if you committed crimes and so then it cannot be converted into labor or work permit or other permits. This is what at least the Ministry of Interior is saying. And we will see if this goes down to this easily also in courts, but this is our job. We will see, and maybe we'll meet in a few months and I will tell you how how this played out.
Yes, thank you very much. Very good to know some of these details also on the point on regularization. Indeed, this is ongoing. So let's continue the discussion. I think it's also, as Wiebke has said, with how the Duldon is playing out and Ms. Zippel as well. All of these are ongoing files. So we need to continuously be updating ourselves and yeah, providing evidence of where the challenges are as well. We have a couple of minutes left. In the meantime, our colleague will put in the chat a link to an evaluation form, which we invite all of you to fill out if you have a chance. And our last question will be for Marta. Very briefly, Marta, you mentioned that one of the reasons for which people cannot return or be deported is because this would violate the principle of non-refoulement. Can you explain briefly what this means in practice?
Yes, thank you. I will be short. I think, put it briefly, the principle of non-refoulement states that states cannot return or deport people to a country in which some of the most fundamental rights would be at risk. And these include risk of persecution, torture, ill treatment, or also other fundamental rights. It also prohibits states to transferring people to a country in which they would be at risk of further transfer. And this is what can be called chain refoulement. So if one state transfers someone to another country in which their rights are not directly at risk, but then there could be further transfer. For instance, because of the lack of protection they would have in that country, because in that country they would also be undocumented and therefore be at risk of deportation. What is very important when we talk about the principle of non-refoulement is that it is an absolute principle and it cannot be breached for any reason. And for these and other reasons, it is broader than what is assessed during the asylum procedure. It is broader for 3 reasons. First of all, as also Alberto mentioned when presenting some of the reasons for which people may receive the permit for special protection, is that if people have committed a serious crime, they may be excluded from international protection, but they may not be excluded from the scope of the principle of non-refoulement. Therefore, the deportation would still be illegal. Secondly, when we look at the principle of non-refoulement, it's important to look at the risks that people face in the country in which they are returned and not only in their home country. And this is particularly important when we look at refusal of entry at the external borders, because people may be sent back to a state in which they have just transited, which may not be the state of origin, which for stateless people is not the country of habitual residence. But it's important the states also consider what risks they would face in that specific country. This applies, just drawing from very recent events, this applies to people who are not Ukrainian nationals who cannot be pushed back in Ukraine, but also applies to many other situations in which people cannot be pushed back to countries in which their rights would be at risk, even if they don't come from that country. For instance, people who are pushed back in Libya, even if they're not from Libya, despite very clear evidence that their rights would be at risk. And the third reason why this is broader than asylum application is because it covers very different types of human rights. The cornerstone of the principle of non-refoulement is the prohibition of torture and ill treatment. This is in the European Convention on Human Rights, in the Convention Against Torture of the United Nations. But in reality, the principle of non-refoulement is broader than that. It also, for instance, covers people whose health would be at risk if they would be deported. There are court decisions which also show that mental health should also be considered. So people who suffer from mental health would also be covered by the principle of non-refoulement for mental health diseases. Also, other fundamental rights violations, such as degraded living conditions or serious forms of gender-based violence or prolonged solitary confinement, can also lead to a violation of the principle of non-refoulement if people are returned in certain circumstances. With regard to the application of this principle, courts are very clear that this principle applies every time that a state exercises jurisdiction or effective control over a person. This means also, for instance, people who are in international water. And this means that this principle also applies in situations which could be potentially covered by the so-called fiction of non-entry that the EU proposals on the pact would be introducing. This principle should also apply. And what it means in practice is that states have an obligation to assess each case individually. They should set in law procedures to do so. And if people appeal against a decision which would return them in violation of the principle of non-refoulement, their appeal should have a suspensive effect. I will close here because for sake of time, thank you.
Thank you very much, Marta, for outlining that. As PICUM, we would definitely like to thank all of you who've spoken as panelists, Ms. Birgit Sippel as well, from the European Parliament, for your guidance, your leadership on this. And for all of you watching as well, for the ability to collectively unpack some of the things which seem rather simple sometimes when they're presented at the EU policy level, but which actually are very complex, which are very nuanced, and which actually have a history in member states of legislation and practice. And so it's really important that we collectively think through these things and show the evidence from the ground of what all these protection statuses are, the principle of non-refoulement, the nuances of it, so that we really ensure that a fundamental rights approach is very thorough and it's thoroughly applied in practice. So we hope that this webinar has been useful for you, and we continue to look forward to unpacking it and discussing it together and to moving forward. Thank you very much once again.